another. Each party must try to convince the arbitrator of the correctness of its position. Your attorney will give an opening statement that clearly describes the controversy and indicates what is to be proved. Next comes a discussion of the remedy sought. This is important because the arbitrator's power is conferred by the agreement of the parties. The witnesses are introduced next in a systematic order to clarify the nature of the controversy and to identify documents and exhibits. The process ends with a closing statement that should include a summary of the evidence and arguments and the opportunity to respond to points made by the other party. As in mediation, you should demonstrate a cooperative attitude, respect for the process, establish rapport, empathy, and sincerity. Your personal appearance needs to reflect this. The award is the decision of the arbitrator on the matters submitted to him or her under the agreement. If the arbitration panel consists of more than one arbitrator, the majority decision is binding. The purpose of the award is to dispose of the controversy finally and conclusively, and to rule on each claim submitted. The arbitrator is usually empowered by law to grant whatever relief would have been available in court. As a matter of law, the award must be in writing. The arbitrator will have an allotted amount of time, usually 30 or 60 days, to make his or her decision. The power of the arbitrator ends with the decision. However, unlike a trial, there is no right of appeal from the arbitrator's award. With alternative dispute resolution, it's important to remember that what you're trying to accomplish will dictate which method you should consider. You and your attorney need to look at what your objectives are and whether mediation or binding arbitration best helps to achieve those objectives. Each method has its own particular strengths and weaknesses. You and your attorney need to discuss what issues are really important to you. Issues such as minimizing costs, speed, privacy, maintaining relationships, vindication, and/or maximizing your recovery need to be addressed so that you and your attorney can decide which method is best for you. Remember that arbitration is less formal than litigation, and mediation is even less formal than arbitration. Unlike an arbitrator, a mediator does not have the power to render a binding decision. A mediator does not hold evidentiary hearings, as would an arbitrator, but instead conducts informal joint and separate meetings to understand the issues, facts, and positions of the parties. In contrast, arbitrators hear testimony and receive evidence in a joint hearing on which they render a final and binding decision known as an award. Your role is to establish rapport, empathy, and sincerity. You must be honest, straightforward, and listen to the counsel of your attorney. Remember, there are many benefits to using alternative dispute resolution. It can be fast, provide early settlement, cost less, and act as a forum for more flexible, creative solutions to disagreements than does traditional litigation. Work with your attorney to evaluate which method best meets your needs.